Call the third case on this morning's docket. Case number 115648, State of Kansas v. James A. Qualls III.
May it please the Court, Mr. James Qualls appears through Counsel Casper Shire, Appellate Defender Office. Your Honor, could I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Your Honor. In July of 2008, a fight at the Whiplash Bar here in Topeka, Kansas ended in a fatal shooting. As a result, Mr. Qualls was charged with the premeditated murder of Joseph Byer. Earlier, this Court reversed a conviction on that charge due to instructional errors at the first trial. At the 2014 retrial, as at the original trial, Mr. Qualls presented a theory of self-defense. He was convicted of the same charge. In this appeal, he cites several errors, including denial of Mr. Qualls' request for relief under Brady v. Maryland after the state withheld an exculpatory coroner's opinion until the fourth day of trial, and also several instructional errors, including failure to instruct on self-defense and failure to instruct on voluntary manslaughter. Now, unless this Court directs me elsewhere, I'd like to begin with the self-defense issue. A requested self-defense instruction must be given when it is legally and factually appropriate. The evidence must be viewed in the light most favorable to the defense when making the factual determination. Here, the trial court denied the instruction, finding that the evidence did not support an objectively reasonable belief that self-defense was necessary.
And she focused that on the lack of a deadly weapon being present anywhere at the scene. That seemed to be the focus of her denial.
I think that's a fair statement, Your Honor. But here is the evidence in the light most favorable to Mr. Qualls. The Whiplash Bar was crowded and noisy. The bar had a history of violence. The events unfolded extremely quickly. Mr. Byer had been acting aggressively during the evening.
Where do you get the bar has a history of violence from?
I would cite to volume 43 of the record, page 464. I believe it was the bouncer who testified that he'd broken up fights at the bar before and taken weapons off people at the bar. And I think that's a fair inference to be drawn from that testimony, Your Honor, in the light most favorable to the defense. Mr. Byer had methamphetamine in his system, which can cause aggressive behavior. Now, shortly before this happened, Mr. Qualls was trying to de-escalate a pool game argument when Mr. Byer sucker punched him, and he was then placed in a chokehold by the bouncer at the bar and briefly lost consciousness. When he came to, he testified that he saw Mr. Byer reaching for his waist as if for a weapon. Shortly after the shooting, several people with handguns tried to force their way into the bar, and Mr. Qualls' vehicle was struck by several bullets in the parking lot. Based on those circumstances, a reasonable person could feel that self-defense and defense of a person's family was necessary. Now, the jury may have accepted some, all, or none of that evidence. The problem in this case is they never got the opportunity to weigh it. And that is because the district court, in denying the instruction, substituted its weighing of witness credibility, its weighing of the evidence, and its factual findings for those of the jury.
Let's say we, for argument's sake anyway, we agree with you that the self-defense instruction under these qualifies should have been given. In terms of, and you would agree we would then go to a harmless analysis. What impact, we sent it back because we said that voluntary manslaughter, imperfect self-defense should have been instructed on.
Yes, Your Honor.
And that instruction was given, correct?
Yes.
And can we make anything of the fact, and they were told to consider it along with first and second degree, you're told to consider that instruction. And I know it's different. And I know it's not an affirmative defense, but that instruction includes self-defense. Is that something we could say that the jury considered that, and while not exactly the same, they dismissed self-defense, at least as it's instructed here, Would that be part of the equation we would look at?
My answer to that, Your Honor, would
Because
be...
that's different. The first time we said it was it was not harmless. But here we have this, and that's a difference.
It is a different instruction. And I think had the instruction been properly given, it would have changed the dynamic of jury deliberations. You are correct. They were instructed on voluntary manslaughter, imperfect self-defense. That means if the evidence presented to the jury proves beyond a reasonable doubt that Mr. Qualls had a subjective belief that self-defense was necessary, they can convict of that lesser included. As a practical
It is a
matter,
consideration of the theory, anyway, of self-defense.
to an extent it is, because it effectively places the burden on Mr. Qualls to prove that element. The state isn't going to do it for him. Had the jury properly been instructed on self-defense, the burden shifts to the state to disprove Mr. Qualls' theory of self-defense beyond a reasonable doubt. And that's an entirely different jury deliberation.
But was it at the entire state's case that this wasn't self-defense, that, you know, him putting his hand near his waist is not evidence of a gun? That was the argument, that this was a premeditated, intentional act. Nothing provoked Mr. Byer or Mr. Qualls into this action, this conduct.
That was the state's evidence, Your Honor, and the jury never had the opportunity to weigh that evidence.
Disproving self-defense?
The jury could have taken that way, Your Honor, but they didn't have the opportunity because it was never presented to them. The jury could have concluded that the state did not meet its burden of proving beyond a reasonable doubt that, of disproving beyond a reasonable doubt that Mr. Qualls had an objectively reasonable belief that self-defense was necessary in that situation.
I understand the difference. Yeah.
All the jury verdict shows is that Mr. Qualls did not prove himself beyond a reasonable doubt that he did have a subjective belief. And I think that's particularly important in a case like this because the jury did spend 10 hours deliberating on this case. They started on a Friday afternoon and they didn't finish until after hours on Monday. That tells us that it was a very close case. And I'll also remind this court what it said the first time this case was here and when this court reversed for an instructional error. It said that Qualls' defense theory was that he shot Byer because he believed Byer was reaching for a gun. Qualls never departed from that theory. Qualls did not make any statement before the shooting from which premeditation could be inferred. In other words, we hold the evidence of first-degree murder was not so strong that it rendered the instructional error harmless. As applied to that analysis, nothing changed in the second trial. The error was not harmless then, and the instruction error was not harmless in this trial either.
Except you've acknowledged that the jury did not find that he had a subjective belief that he needed to use deadly force.
They found that Mr. Qualls had not proved beyond a reasonable doubt that he had a subjective belief. That does not mean they would have found that the state disproved it beyond a reasonable doubt. Those are two different things, Your Honor.
But that's different between the first time we looked at this and now.
That would be the only difference, Your Honor. Yes. Unless there are further questions there, I'd like to turn...
I guess, and again, I dissented in the first case, and I still have the question, how are 12 shots fired into someone, 4 of which hit the victim in the back? How could that be self-defense? At least at some point it becomes an act where you're intending to kill. Explain to me how you get an instruction under these facts. And I understand how his testimony, and he was afraid, and he was, but just given the act here, articulate that for me.
Because, according to statute, the evidence must be viewed in the light most favorable to the defense. That means that the court must
view that in the light most favorable to the defense. Those just 12 shots, 4 in the back.
And that must be weighed against all of the evidence which supported a subjectively reasonable belief that self-defense was necessary. And the court must weigh that evidence in the light most favorable to the defense. In other words, they must conclude that the jury takes that all, believes it all, and that they disregard the evidence that is disfavorable to the case. That's all that's required to get the instruction. I think the analysis that you're asking for is exactly the analysis that should be happening in the jury box, and here that didn't happen.
Right, I understand.
But take that same fact and put it in the harmlessness inquiry, and why would we not determine that if someone had been shot 12 times, 4 of them in the back, that the jury was unlikely to have said this shooting was in self-defense?
Well, first of all, they spent 10 hours deliberating, so obviously they felt that it was a close case.
I don't think you could say that, but just my experience with juries, sometimes they're fast, sometimes they're slow, sometimes it's one, you don't know that. That's entirely speculation.
Counselor, isn't the premise faulty here? The determination is whether this individual felt that deadly force was necessary to protect him and his significant other. And if deadly force is necessary to protect oneself, then you can use that force, and you're going to use that force, full force. You're not going to go halfway in protecting yourself. So the fact that he emptied the magazine is what you do when you're making sure your family's not killed by a deadly aggressor. And so the number of shots doesn't answer our question. Our question is whether he legitimately exercised the first shot to protect himself and his family. Isn't that what we're talking about?
Yes, Your Honor, and just to add to that, the testimony was that it was a semi-automatic weapon that fired very quickly, and in fact, the entire shooting happened extremely quickly in the matter of just a few seconds. All of that speaks to whether or not the act was premeditated or not, and I think especially given the favorable evidence that a jury could reasonably have concluded that this was not premeditated and in fact was an act of self-defense.
On harmlessness, which harmlessness standard do we apply?
This error speaks to Mr. Quall's ability to present his theory of the case, which was self-defense. That is a constitutional issue, therefore I believe this court has to apply the harmless error standard.
The constitutional harmless
the constitutional harmless error standard. Yes, Your Honor. I would like to touch on the Brady issue as well. The state's theory of this case, which they repeated at least 3 times in their closing, is that Mr. Byer was pinned against the wall of the bar face first by another bar patron when the shooting started. Mr. Qualls obviously testified that he was away from the bar and that he saw Mr. Byer reaching as if for a handgun. That was the basic factual discrepancy that the court was that the jury was tasked with working out. The issue comes on the 4th day of trial because that's when defense counsel first learns that the state's coroner is of the opinion that based on bullet trajectory and where people were standing, he could not have been pinned face first against the wall. Because he doesn't find out about that until day 4, we have a Brady violation, which also demands that this court vacate the conviction.
How is that a Brady violation?
Well, Your Honor...
Didn't it come to the coroner was testifying and then counsel spoke with the coroner during a break, as I recall? Is that kind of the scenario? Got this information that a week or 2 prior to his testimony, he reviewed the video and said the location of Mr. Byer was slightly, I don't think it was that significant, but was different than what he first thought. How is that Brady information when, one, it was, there's no showing that it was withheld by the state. This was the coroner's kind of looking at, in preparation for his testimony, altered his opinion of, maybe not even opinion, but his view of where the body was.
Well, Your Honor, I think it does meet all 3 Brady prongs because first, it is exculpatory. The state, at least 3 times in its closing argument, proceeded with the theory that Mr. Byer was pinned face first against the wall at the time of the shooting. The coroner's opinion directly refuted that. It supports Mr. Quall's theory of the case. It undermines the state's theory of the case. And you're right. The state knew about this opinion 2 weeks before it got disclosed to trial counsel by getting shaken loose during cross-examination. So they had it for 2 weeks and they didn't say anything, even though they knew it directly undercut their theory.
Was there some information the prosecution that knew about this? Or?
Yes, Your Honor. That was at the Brady hearing. The coroner testified that he came in to watch the videos at the county attorney's request. He watched them in their office. He formed his opinion there, and he told them about it. That was all in the Brady hearing.
But it was based on a video that was available to the defense, right?
Yes, Your Honor.
And it's not, was there anything that required an expert view of that video for the expert to draw a conclusion different than the jury could draw from watching the same video?
Yes, Your Honor. In fact, the defense tried to retain their own expert to render a very similar opinion. That's how all of this got started. The state actually brought in their own witness to attempt to rebut the expert that defense was prepared to put on the stand. That expert ultimately did not get certified, which is a separate issue in the brief. But I think it really goes to the materiality issue that the state felt this was important enough that they needed to bring in their own expert to rebut this testimony. And then they turn around and say it's not important enough, not material enough to turn over for Brady. And I think that's inconsistent, Your Honor.
Do we have any further questions? All right, thank you, counsel.
Thank you.
May it please the court. Rachel Pickering, Assistant Solicitor General, on behalf of the state. There were several issues raised in Mr. Quall's second trial direct appeal. I had first wanted to address issue 2 and really pinpoint and respond to the questions that Justice Rosen asked the defense, which really gets to the point. Yes, this court can consider the new instruction that was given to the jury at the second trial. The fact that the jury received a imperfect self-defense.
Before you get to harmless, that's where you're jumping right.
Oh, I'm
to
jumping.
Let's talk about whether the instruction was warranted in the first place, and tell me that Mr. Qualls testified pretty clearly, maybe even clearer than he did in the first trial, that he'd been hit, threatened, told to go out of the bar before anything worse happened, and then he thought he saw Byer reach into his pants as if he was going for a gun. I just stated what he stated in a long, lengthy testimony, but that's basically what he testified to.
Right.
And given that, why wasn't the self-defense instruction appropriate?
Because that fits the imperfect self-defense instruction. That does not, thinking somebody puts their hand to a waist.
Why isn't that a reasonable belief?
That's not a reasonable belief that a person has it has to be a reasonable belief that that your reasonable believes deadly force is necessary to prevent imminent death or great bodily harm.
And
Reaching
just that alone, what I just recited to you, why isn't that enough to get the instruction?
Because reaching for your hand on your waist does not get to reasonably deadly force is necessary to prevent imminent death of unlawfulness. We do not have deadly force there. We do not have the sight of a gun.
What if the defendant reasonably believed the victim had a gun? Isn't that what he testified?
Having a gun is not unlawful force. Two men could be
Having
in an
a gun
argument.
and having the person being reaching for it in the context of ongoing violence over the course of the night.
Well, it was a short time frame. They had separated. He had a 400-pound man between him, Mr. Byer, and Qualls, the defendant. Knowing he has a gun should never allow a person to reasonably believe that deadly force is necessary, especially in this day and age of people carrying guns. It does not get to the point where they can then start shooting to make sure he did have a gun. So we would argue you have to get to what the statute is. Reasonably deadly force is necessary to prevent imminent death. So having a gun does not still get you to imminent death.
You have to
Displaying
wait till
the-
the gun is out and pointing at you before you can defend yourself.
We would want there to be something of that nature. Having a person's, you could talk to somebody and you know that they have a gun on, right in their legs, in the pant leg, and they hold it and that's where they carry it. I have an argument with this person, but that doesn't mean I get to start shooting.
Well, Ms.
Because-
Pickering, it was more than an argument. Didn't Mr. Byer hit Mr. Quells twice over the course of this incident?
I believe he did hit him once.
So, I mean, twice, wasn't it?
I'll go with your memory than mine.
I mean,
But they
just
had
as
separated.
Stigl asked about that, but within this context, I appreciate what you're saying, but within this context of what was going on,
Right.
you're saying that's still,
It doesn't get us. It doesn't get us to self-defense when the two men have already now separated. Why are you defending? Why is there a self-defense if the men are now separated? And so, and Qualls is a bigger man than Mr. Byer.
But hadn't Byer also shouted at Qualls that he'd better get out of the bar while he still could?
Yes.
I mean, that's a pretty significant threat that, it at least can leave the impression that if you don't get out of here, I'm going to do something so that you can't,
right.
which could be shooting. And especially if there's a movement that someone would think was a movement towards pulling a gun, combined with that statement and the punches that had been thrown before, that seems pretty threatening.
But is that unlawful force? I'm very, very concerned that a person yelling and then having a fight and making a hand movement gets the other person to say, I have to defend myself against you. That, to me, really goes to the imperfect self-defense.
But who gets to decide? Who gets to decide whether it's reasonable to react to the movement or whether the gun has to be in plain view? Isn't that a jury decision?
It is.
Does the prosecutor get to decide?
No, of course.
Does the judge get to decide?
No, Justice Johnson, that is a jury question if there is some evidence to support that instruction. And the state's position has been
So
there is
you-
not evidence of self-defense.
So you have to say, as a matter of law, under these facts, that it cannot be self-defense. That's what you're saying is, and as a matter of law, the gun would have had to have been viewed before the defendant could use deadly force.
Well, let's add some more factors.
No, is that what you're saying?
Well,
Under these facts, we got the facts here. We all know what happened. Under what would have taken
Yes.
here to meet as a matter of law to
Yes.
meet a jury question is that the gun would have had to have been in view.
Or a weapon, a gun or weapon. Yes, we are going to take that position. Absolutely. And that is,
I'm sorry, go ahead and finish.
and that goes
comment.
with the 609 letter that the state presented to this court's attention, as it well knows, came out November 21st, State v. Haywood. State v. Haywood, the victim was charging the defendant with a knife. And this court said, you know what, in those circumstances, you have a victim charging the defendant with a knife. Yes.
So you see a distinction here between Haygood and what the facts here. What's the difference? You said in Haygood, the assertion was that the victim was attacking
Correct,
him with a knife.
correct.
And here, all we have is a movement to his waist.
Right,
Well,
and things
could-
had settled
could
down.
Can I interrupt on that? Because it was something I was going to ask after Justice Johnson's question.
Okay,
We said in Qualls that Qualls said he saw Byers' hand go to his waist and then, quote, saw an object.
right,
I saw something, but I couldn't make it out, unquote. So this is someplace a little below what we had in the case you just referenced, Haywood. It's not actually seeing a weapon, but seeing an object. It's
Right.
not like he just went to his waist and there was nothing in his hand. So just to get back to the questions here, are you saying that the defendant in a case has to see what he or she knows is a weapon?
well, he was guessing. I'm
Well, that's
very,
what I'm trying to nail down here, taking the skin off the onion one layer at a time.
we would argue you would have to see a weapon and not just guess when you're reaching at the waist.
Well, but guess what the object was that was in the victim's hand.
Yes,
All right.
because with that, I say that with full confidence, Your Honor, because the defendant did receive the imperfect self-defense, which is even more favorable to Mr. Qualls. Well, he thought he saw a gun, but he didn't see a gun. Girlfriend testified there's no gun. Police officers testified no gun. No gun found on him at the scene. So we gave them more favorable instruction than self-defense. And so to answer your question, Your Honor, in those situations, if you don't see a gun and you start shooting, imperfect self-defense would be the best instruction to give. And that's how this court held the first time.
Well, no, we didn't reach the question of self-defense the first
Right,
time. We
I meant-
didn't. And so your
meant-
position is that if you get a voluntary manslaughter in perfect self-defense, that negates the need to give a self-defense instruction?
No, we would argue that the factors in this case, and I'm repeating myself, fit imperfect self-defense. The concern is if somebody touches his waist, we do not get to the point of unlawful, which is what you need in the statute, unlawful force.
Ms. Pickering, though, the imperfect deals with an irrational. The self-defense regular instruction deals with a reasonable. What about a discerning jury that could be looking at one and say, well, this looked pretty reasonable, but that's not the judge or the court instructed on?
Okay.
I mean, you're arguing they're kind of the same, or that he got a better instruction, but aren't they different?
They are different. Yes, they are different. A juror would have to find that somebody touching his waist indicates he has a weapon would be reasonable. We would argue that that wasn't supported by the evidence, but there is a distinction. Yes, Your Honor.
Thank you.
Would you agree there was evidence of self-defense of a less than fatal nature? That there was reasonable to believe he needed to exercise some form of self-defense, just not to the level of killing Mr. Byer?
We would argue no, because the two parties had separated at that time and were separated by two big men. So even though Mr. Byers may have been yelling at him, you had physical barriers stopping the two men from engaging into each other physically. So we are not of the position that simply yelling aloud would cause Mr. Qualls to have to defend himself. That he said he was leaving, and that would have been the better route to go. Because Mr. Byer wasn't throwing punches at him. Get out of here is get out of here. And they had separated. And that's what happens when fights end. There's still talk back and forth, but the two parties do stop. Now, if Mr. Byer had started swinging, we would have a different situation. Now, in my argument, I jumped forward to harmlessness. And I wanted to jump back to that while I still have time. Justice Stiegel, you had asked the defense which standard of harmless would you use? And in our brief on page 30, we've implied the more favorable harmlessness analysis. Even under the most stringent harmless analysis test, there is no reasonable possibility that the error contributed to the verdict. So even in the most favorable light to Qualls, you still have Mr. Byer not being armed, no customer seen him armed. You have a victim who is being shot multiple times. In fact, at the cross-examination, he said, the state asked, and that gun is such that you didn't pull the trigger once and all 11 bullets ejected, right? Mr. Qualls, no. Prosecutor, each time that gun fired, you had to pull that trigger, right? That's correct. So we have over 9 to 11 shots triggered each time by Mr. Qualls. He kept firing. As Justice Rosen said, 4 shots to the back, and where at one point he's down on all fours, and finally where he lies dead and dies within hours. The fact that Mr. Qualls kept on firing at the Mr. Byer.
I guess I don't understand that. If the first trigger pull is legally justified, why isn't the 11th trigger pull also legally justified?
Because the whole point is self-defense. And the first trigger pull should be 1 gunshot should be enough.
Well,
If you're defending yourself, 1 gunshot.
So someone who has a legal right to self-defense loses that right after they shoot once. That's your argument.
No, the argument is if you're going to throw out a gun for somebody who's unarmed and think that they have a gun.
No, the premise of my question is that the first gunshot is legally justified.
Correct.
And you're arguing that somehow 11 shots is not justified. And I don't understand the logical leap. That's all I'm asking.
The logical leap is, what is your whole point of self-defense? To disarm the person? Or is it to kill them?
No, it's not. If you're entitled to use deadly force against deadly force, what is deadly force? It's not to wound.
Right.
You're not entitled to use wounding force.
Right.
You're entitled to use deadly force. And so just because you accomplish what you started by successfully exercising deadly force, that doesn't make it unauthorized in the beginning. Either you can use deadly force or you can't. I don't know of a deadly wounding force concept. And that's what my colleague is getting at. If you can use deadly force, then you can be good at it and accomplish it.
Can you use it so that it is... Let me get this right. To answer your question, Justice Stiegel, when he's down on the ground, isn't that enough? I guess the state does have a position of 11 bullets. If he's down on the ground, shouldn't the person stop? All right, he's dead. Do you get to keep on shooting?
You're saying
Go
ahead.
I was going to say, she was trying to answer your question based on the premise that the deadly force at the beginning was justified. I understood your argument to be all these things that happened later.
Correct.
The 11 shots, as the dissent in Quall said, he was leaning over a table to shoot
Correct.
him on the floor. That all went to the threshold question is whether deadly force was justified in the first place, because all these factors suggested that he was intending not to defend himself, but he had it in his head that he needed to kill this person for his own purposes, not self-defense. So that's where I understood the...
Yes, that is correct, Your Honor.
Okay. So you're not able to answer their question.
Well,
Because you're answering what happened later to say he was never justified in self-defense.
well, I guess my position is, if we're going to look at harmlessness of whether the jury would have found this, certainly a jury would have factored in 12 gunshot wounds to the defendant to show. I will stick with this, Justice
Well,
Stiegel. I understand your point, but I do believe that the fact that 12 gunshot wounds were put into an unarmed man does go to the harmlessness. And I don't have a case in front of me that would show 1 bullet versus 12, but we believe it does go to the fact of the jury would not find a self-defense.
But you're a moving target. I agree that shooting 11 or 12 times at an unarmed person, that's a whole different scenario. That isn't what the question is about. If you thought you had an armed person that was going to attack you with deadly force, that's the premise.
Right.
That's
right.
the premise. And you have a point at which you have to stop using deadly force if you're in the process of doing that. And you're saying that you do. There's a point at which you have to stop using deadly force.
Yes.
If you think you have them disabled.
Correct. I don't think you get to take out your knife then. And let's now stab him. I'm being sarcastic and I apologize, but I believe that there has to be a reasonableness to this.
How many of the shots were lethal?
There was one to the chest, to the back, that went through the chest, and so the pathologist said that was lethal. There were some that just hurt the surface. There was one that hit his penis that I would assume would also be part of that lethal, but there were definitely lethal shots. I don't know how many.
You're out of time, but real briefly, do you want to respond to counsel's Brady argument?
Yes. There are 3 parts to the Brady analysis. One goes to the, and I apologize, how much time do I have to answer?
Well, just.
You'll take whatever time you need,
Thank you.
subject to my judicial discretion.
Oh, sorry, thank you. So there are 3 parts to this test, and I'll go through it. The issue has to be favorable to the accused, must be suppressed by the state, and must be material to establish prejudice. None of these 3 factors fit here. One, because Justice Rosen, I apologize for calling you out, but you're absolutely right. I'm assuming it was taken as right. This is not an opinion that he's given. This is a video that the jurors see. This is a video that the defense has seen. This does not change the opinion of who this person is. And who is this person? This is the pathologist. So what is he going to opine to? He's going to opine to the gunshots. He's going to talk about the gunshot wounds. He's not talking about recreating the scene. And so our argument is, before we jump into what the defense heard, which, as was pointed out, the defense did hear, was able to cross-examine the pathologist, he is not modifying his opinion. He does not modify his autopsy report. He does not modify. He doesn't know which shot came in first. He can't say where they all landed. He just now knows, okay, the victim was standing, not pinned against the wall. So we would argue this.
The coroner never offered the opinion that he was pinned against the wall?
No, I don't believe so. So we don't even get to favorable, because it never changes his opinion. 2, was it suppressed? Well, the prosecutor tells the defense counsel, he's right in the hall, you can go talk to him right now. They never saw it as new evidence. And 3rd is the prejudice, and that is on page 867 in volume 45. The defense is able to ask the pathologist about this. Question, but after watching the video, did you have additional opinion about the position of the body? Yes, I discovered, that I thought before him, I could tell the location of the person in the room. Again, it didn't change my opinion on the gunshot wounds. So the jury now hears what the defense is arguing is Brady evidence. We argue it's not. So where's the prejudice? Evidence must be material so as to establish prejudice. In our brief, we discussed how this would not impeach the 3 other witnesses, Casey McDonald, Mark and Amber Martindale, and we would argue, Mark Patrick, and we would argue the jury did hear about this, and therefore this was never a Brady violation to begin with. Thank you for your judicial discretion, Your Honor. I would conclude by asking this court to affirm Mr. Quall's conviction.
Do we have any more questions? Thank you, counsel.
Thank you.
I'd like to pick up with the Brady violation and speak especially to the first and the third prongs. The opinion that the coroner gave on the 4th day of trial was that Mr. Byer could not have been pinned face first on the wall based on the trajectory of the bullets and where the parties were standing in the bar based on his review of the video 2 weeks earlier.
Did that change a prior opinion that he had expressed?
No, but it was new information. It was not testified to at the first trial, and it was not included in his report. So this is the first access the defense counsel has to that information. It's important, it's material, because at least 3 times in closing argument, the state argues specifically that Mr. Byer was pinned against the wall face first. This directly refutes that. It is exculpatory evidence.
But didn't you, that evidence was then considered? I assume defense counsel argued that the coroner said he wasn't pinned against the wall.
They did, yes, he did in closing.
I understand the time, I understand all that, but you were able to argue that based upon the coroner's testimony, based upon the cross-examination.
Yes, but I believe it still prejudices the defense in 3 distinct ways. 1, they should have had this information 2 weeks earlier. It robs the defense of the ability to effectively prepare for trial in those 2 weeks. If they know they have this opinion, they're going to prepare differently. Their limited hours are going to be spent somewhere else. And in a case this close, that could have made the difference. Second, it robs the defense of the ability to confront adverse witnesses with an adverse expert opinion. There were witnesses who testified with varying degrees of consistency and certainty that Mr. Byer was or may have been pinned against the wall of the bar face first. Defense counsel lost the ability to confront them with this opinion because he didn't know about it until day 4.
Was that evidence offered prior to?
Yes, those witnesses testified on days 2 and 3 of the trial. Third, and probably most importantly, the defense was robbed of its ability to front-load this information in its opening statement and frame their theory of the case, which was self-defense. The prosecution had the opportunity to stand up and tell the jury, you will hear evidence that Mr. Byer was pinned face first against the wall.
So that was in their opening statement?
If I remember correctly, it was, Your Honor, yes. And it was definitely in their closing statement. And defense did not have the corresponding opportunity to stand up and say, you will also hear evidence that an expert doesn't believe that's possible. And again, in a case this close, that could absolutely have been the difference. So because of the failure to instruct, because of the Brady issue, we are asking this court to reverse Mr. Quall's conviction. We believe that individually it requires reversal. We believe that cumulatively and cumulatively with the other issues in his brief, this court must vacate his conviction. Thank you.
Counsel, I had a question. Prejudice the other way. You've talked about prejudice to the defendant. What about a prosecutor who has the expert's opinion that has now been changed and it contradicts the position the prosecutor is taking? That seems rather prejudicial to the state to have a prosecutor do that when confronted with expert witness or the coroner's testimony that's just the opposite of what the prosecutor is saying all the time. So does that factor into our analysis at all?
I don't think it does, Your Honor, for 2 reasons. One, the state chose to double down on its theory that Mr. Byer was face first against the wall. They continued pressing that during cross-examination. At least 3 times they stated that fact. So that's one. And 2, I simply don't think prejudice to the state factors into Brady analysis. This should have been turned over earlier, and even if the state suffered some prejudice by learning it later than they might have. They still knew about it before defense. They didn't turn it over, and during those 2 weeks, especially on the first few days of trial, it was defense that suffered the consequences.
All right, thank you. Any more questions? Thank you, counsel.
Thank you.
Court will take this matter under advisement.